By all standards, this new act is harsh, and our taxmen intend to deal with the issue of black money with an iron fist. But hold on, before a tax evader is officially caught and punitive action is taken, the government has notified a friendly window which invites all such residents of India who have undisclosed assets abroad and promises to bail them out if they make an honest disclosure and earn their peaceful sleep by paying 30% tax and 30% penalty. Now the larger question is, how successful is going to be this window, notified as compliance window by the CBDT? Although the government hates to use the expression amnesty for this window, but for tax evaders it is nothing but a sort of amnesty. Before I take you to my panel of experts who will be examining the fine prints of the scheme, let me give you a glimpse of the quantum of revenue collected by developed economies by introducing amnesty schemes, not once but even twice. Australia mobilized revenue as much as 210 million Australian dollar in 2010 and 11. France and Germany collected euro 1.2 billion and 1.8 billion respectively from such schemes. Italy seems to have made a big fortune by introducing such a scheme not once but twice and mopped up 5.6 billion euro. Let's now go to our panel for more insights into the provisions of the compliance window.
Hello and welcome to Simply inTAXicating. With the President of India giving his assent to the Black Money Bill on May 26th, the CBDT has notified the new Black Money Act with effect from 1st July 2015. Taking a few cues from the VTIS scheme of 1997, as promised by the Union Finance Minister on the floor of the House, the CBDT will roll out a compliance window. It's a one-time opportunity for all those who have assets abroad and which have not been declared to the tax authorities in India. They have an opportunity to make a declaration, pay 30% tax and 30% penalty and earn a good slip. CBDT has come out with a very detailed FAQs. The larger question is whether the FAQs explained by the CBDT are good enough to persuade or to encourage a prospective declarant to come out and make a declaration. We have four distinguished panelists with us. We have Mr. Sunil Chopra, the former Chief Commissioner of Income Tax. We have Poorva Prakash from Deloitte Haskins. We have Mr. Rohit Jain from Vaish Associates. We have Mr. Sunil Agarwal from AZB Partners. So let me start with very basic fundamental question with Mr. Chopra. Sir, please tell us who all are covered and who all are excluded from this compliance window scheme.
It covers the residents. Even non-NORs are excluded from the scope of this act. It's a conscious decision of the government. So residents are taxed on their worldwide income as per the scheme of the Income Tax Act, and the target of this legislation are those residents who have earned income abroad or who have created asset out of their income earned abroad but have not declared that income or assets in their income tax returns in India. So this is the target, and this is a very important piece of legislation. Under the normal scheme of the Income Tax Act, in the case of foreign income and foreign assets, the assessment can be reopened only for a period of 16 assessment years. So far as this act is concerned, there is no such limit. There is no such limitation.
It goes back and back and back.
The example they have given is of a 40-year-old incidence of transaction, which was undisclosed foreign asset.
Essentially, of course, the Act is applicable. What they're saying is it's applicable from 1st July 2015 to people who qualify as resident. So from an individual perspective, they have to be resident and ordinarily resident in India. And of course, the rationale being because, they are taxable on global income, and they're taxable and their foreign assets have to be reported into India. So therefore, purely from the Act perspective, they're saying, yes, if you have an undisclosed income or undisclosed asset, the way they're defined, your Act will become applicable and all the consequences would follow. But purely from the declaration scheme, the tax compliance scheme, which has come under Section 59, the way they are saying is that they say any person, they're basically giving a window to get back into retrospectively, to see where people have undisclosed assets. So essentially what they're saying is it means any person. So they're really not getting into whether the person would be resident or not ordinarily resident, or a non-resident. What they're saying is that if you earned any income which was supposed to be charged to tax in India, and out of that income, if you acquired an asset and you have not, declared it, then that, you should come clean and make a declaration as per the scheme. So, a lot of doubts are coming that, if I'm not, the scheme is I'm ROR, so the scheme is, should be applicable only to RORs, and why is it going back to NR? So, even the clarifications, what they're saying is that as an NR, say for instance, if you are only taxable on India sourced income. But if that India sourced income was not, you did not pay any tax over there, and out of that income you acquired an asset, foreign, asset overseas, which has to be, then you get captured. So therefore, the coverage is very wide. So it's not really confining to the, the residents or non-residents. So, they're just saying you come clean, make a declaration. If you don't make a declaration, then if officer tomorrow has this thing, he can say it's a deemed undisclosed asset.
What the CBDT has repeatedly clarified in answers to various questions is that you have to find out the year to which you want to offer the income. And in that particular year, whether you are a resident or a non-resident, and whether that income was required to be disclosed before the tax authorities. While Poorva may be right in the sense that the larger issue is that there is no reason why to deny the window to a person who is non-resident, whose income may be taxable in India, but which has not been disclosed. So probably they could come out with an clarification to say that this window, despite the fact that this act per se is applicable only to resident, they can come out with a benevolent clarification to say that yes, we would also accept the declarations by a non-residents or a person who is not ordinary resident if he wants to come forward and declare the asset.
But there are certain clarifications under FAQ 28 and onwards where they have actually given specific instances, where they're saying that even, the coverage can be of a non-resident. So residential status is not an issue over here. What they're saying is that if you had a taxable income over here and you acquired an asset and you did not pay tax, that will be the way it will be get captured.
Regarding this inflow of information, this act has done is it has created a deterrent factor. What if I don't declare? Because now what they have done is they have taken away that 16 years window. Prior under the present act, what could have been done is the income tax department arms could only be taxing you for last 16 assessment years, and they can't go beyond it. Even if they were to able to gather the information relating to say 17 or 18 assessment years prior to. Now this act has created a deterrent because now the year in which the assessing officer gets the information, maybe 10 years down the line, 20 years down the line, he will be able to catch you and he will be able to bring that amount to tax in India. So therefore, this is the only compliance window for 6 months which is available to you. And what if I don't declare is that you face all the consequences.
We will take a short break, and then we will get back to this.
After industrial revolution, the digital revolution which all of us are experiencing today is the next big phenomenon. And it is undoubtedly changing, rather expanding the contours of our existence, whether we live in cities or hinterland. And e-commerce happens to be the heart of this phenomenon. Whether we realize it or not, e-commerce is increasingly becoming an inevitable part of our daily life. However, this rapidly emerging industry is not without its own share of troubles, regulatory, fiscal and many more. Watch out for our episode of Simply Intaxicating e-trouble e-commerce for an incisive analysis of all such issues by the domain experts.
Welcome back. We will continue with the discussion with respect to the compliance window. And let me start with Mr. Rohit. Please tell us with little illustration that what are the steps which are required to be followed by a prospective declarant which would like to avail this scheme.
I'll put it very simply. The first step would be to identify the asset which you want to declare. Now, one thing which is most important is over here is that this compliance window is only applicable to declaration of an asset. It is not applicable to declaration of an income. Now, if an income is in the form of an asset, then you can declare it. But if the income which is not available in the form of an asset, which never formed part of an asset, probably that they don't want to cover it. I don't know why, what is the rationale for this. That's the first step of identification of an asset. The second step is to determine the value of that asset, because the scheme of the act is to tax the fair market value of the asset as on the valuation date. And as per the rules which they have notified, is the valuation date is 1st July 2015. So once you have determined the valuation of an asset, then you have to make a declaration before 30th of September 2015 in Form 6, which they have notified as part of the rules to this act. You have to make a declaration, you have to specify the asset which you want to declare, you have to specify the valuation of the assets which you want to declare, specify the assessment years, and various other basic particulars have to be given in that, along with a clear list of all the assets. And what is more important is what they have also clarified is, supposingly there is an asset which has nil value, but it is always advisable to declare that asset also, because so that there is tomorrow no scrutiny or inquiry with regard to that particular asset. That's the
Because
third
that
step.
will command some premium in future.
Correct.
Okay.
The next step is, then after we have filed a declaration, then we have to wait for the intimation from the department, because if the department already had the information regarding that particular asset, that is outside the purview of the compliance window, and therefore the principal commissioner or the chief commissioner, the commissioner will intimate it before 31st of October 2015 whether they have actually received the information.
And then you are left with only 2 months to pay your tax.
And thereafter you have to make the payment. Once you receive that intimation, thereafter you have to make a payment of taxes by 31st of December 2015. And once you intimate about the payment of taxes, then within 15 days of the intimation of the payment of taxes, they will issue you a form number 7, which is basically a confirmation of your declaration.
So it's an acknowledgement certificate kind of thing that you have paid taxes for the following.
And two things which they have also clarified is that the principal CIT and CIT, while giving you an intimation in form 7, he will only verify whether or not the information has been received by the department or not, so that whether or not you are eligible for declaration. He will not go into any other issue. So your declaration as such will be accepted and basically it will be based on your verification on the declaration form. That is most important.
Okay.
One more point I would like to supplement, which is very critical. You know, when you're making a declaration, you should be very careful while you're making a declaration, because they say that if there is any suppression of facts or something, you know, then it may treat like a void declaration. And then they're also not providing any rectification procedure methods. You know, sometimes there may be a technical error and all. Right now, the clarifications of the act or the rules have not provided. So you should be very careful, you know, actually.
No room for revised declaration.
In fact, valuation, they have also left it open, because I supposedly declare a valuation of say $1 million, and ultimately department tomorrow may dispute that it is not 1 million, it should have been 5 million or say 2 millions.
Once you identify the declarant identifies the assets to be declared, the most important thing is the valuation. And valuation is not simple. Even for such a simple thing as the closing balance of a bank account, he has to have information about when the account was opened, how many accretions, how many deposits have been made, and then come to the final figure. And I understand that even banks may not be able to provide this information beyond a certain point of time. That's one. Second, so far as valuation of those shares are concerned which are unlisted, that's also going to present a problem. So while preparing for the declaration, the declarant has to take into account all these factors, and I would suggest that some clarifications on this, because they have to help the people to come to declare. They should give some clarifications on these ticklish issues.
Absolutely.
In the valuation rule, they have defined, 4-5 specific assets, but then there is a residuary category also, assets. So many a times, sometimes, employees, etc., or the expats and all, they may have a doubt, like, there are overseas social security schemes, pension schemes, medical insurance, 401k plans and all, So what treatment do we do? Like, are they vested asset? They're not vested asset, are they actually my right? So those are the kind of things that they have to really deliberate upon and, kind of come to a right decision, consideration before they make those type of declarations.
But do you think that here, with respect to this valuation, you are foreseeing a lot of dispute, a lot of litigation? Do you think that the suggestions like this, that if the valuer has given determined certain value as a fair market value, that should be accepted prima facie by the department?
There are two aspects to it. Yes. So far as the first part is concerned, they have said that we'll go by the valuation by a valuer who is recognized by the government of that country, like we have the system of registered valuers. So far as the second aspect is concerned, that they go by the valuation of the taxpayer. The purpose is to have as correct a valuation as possible. And if there is an attempt to deliberately understate it, then they can always say that this was misrepresentation of facts and they can reject it. But I don't know whether they have the machinery to reject it.
So, but now it poses a very serious practical problem from the tax administration perspective also, sir. Let's say that there is a declaration on 29th of September. We have 1 month window whereby the department, the principal CIT has to send an intimation, giving details whether your assets, we had the information or not, etc. What is the mechanism with respect to matching or probably accepting the fair market value of certain assets disclosed? The mechanism could be perhaps they will send information to their own offices posted in some of the embassies. Perhaps they will contact the local the authorities there in that respective country. Those authorities will be able to give certain information to this TIOs where they have the income tax officers posted in some of the embassies and high commissions. They will send information in 1 month period, getting all this information, filtering it, matching it. Don't you think that this time period somehow is a little tight?
Time period is tight for a number of things, even for making declarations. When you have difficult valuations, then 3 months period is rather short. But then Section 59 empowers the government to notify the date.
It can be extended. I know, and we still have, even after 30th December, we have 3 more months with us. Probably it could be extended
and
for 2 months.
And there may be one more problem, when they make the payment of tax. Say, for instance, if they don't have a liquid funds, because valuation can be very high, so those are the kind of things can also come up,
that could be a serious
because otherwise if you don't make up payment of tax, then again, I think they will revoke back that declaration.
Absolutely, yes.
So that's another practical problem.
In the case of earlier VDIS of 1997, if I remember correctly, there is a Supreme Court judgment, if I remember correctly, it is Hemlata Gargia, where the clause was that the tax on the income so disclosed has to be paid, shall be paid by so and so date. The taxpayer, because of economic stringency, could not pay by that date, paid later. Supreme Court said no. The scheme says the word shall. Therefore, if you have not paid by that particular date,
you're out of it.
Then you are out of it.
Correct.
Now, I find the similar language this time also.
They have said the declaration would be void if you have not paid the tax by 31st.
So I think the point was that somebody has economic stringency or difficulty.
Right.
So then if somebody who has already disclosed the asset and is asking some time to pay the tax, then the government can consider relaxing the time, maybe subject to charge of compensatory interest.
Right, absolutely.
But the scheme of the Act as it stands now does not admit of this.
That is correct, but because the Supreme Court...
It cannot be answered through an FAQ answered. For that, an amendment is required because that's a substantive provision. The tax has to be paid, tax and penalty have to be paid by 31st December.
But they have said this removal of difficulty.
They have that provision, which is consistent with, like your editorial, which is consistent with the provisions of the Act.
Absolutely,
no,
sir.
In fact,
maybe they can do that.
I tell you that. First of all, sir, with due respect, this Income Tax Act is a unique piece of legislation. It is not comparable to any legislation. Here, the CBDT means just an executive body, it is not legislature, has been given power to pass any order, even if it is inconsistent with the principal provisions of the Act. If it helps the assessees, if it is beneficial to the assessees. Now, this is a unique power which is available to no executive organ.
That was
I just
the
want
point,
to come back to the issue of valuation. Sir said that supposingly there is a difference in the valuation which I declared and the valuation which the department comes out with. And they say that this is an incorrect kind of a declaration, it's a void declaration. I think valuation itself is a subjective matter.
Yeah, it is a
I can come
subjective
out with a
matter.
particular valuation, the other person can come out with a different valuation. Now this is the problem. Now if unless they make a clarification that if supposingly I take a valuation report based on whosoever is the approved valuer and based on that I make a declaration, then in no circumstances that should be disputed. Otherwise it will again lead to litigation.
Rohit ji,
Or
the
they
point-
should come out with quickly with the list of approved, because
And
people
because
are
I-
looking
Rohit
into
ji,
it.
the point you are
that's
making.
So that they have a clarity, people
Yes.
have a clarity if they have
Maybe
it.
sir, you know,
The point what he's making is will not happen in very many cases. The guiding principles have been given in Form 6.
Okay.
That the valuation given by the valuer who is recognized by the government of that country will accept that. This kind of problem can theoretically arise in very few cases.
One very important point, on the valuation, because what they have said is valuation by the approved valuer. See, there are valuations under Customs Act, under Income Tax Act, so they have, there are approved valuers. So, even to that extent, they should in a way say which is a kind of a approved valuer under which act, which can become applicable, because
I
that
agree
is
with you.
where
Yes.
going to be a lot of...
Maybe to avoid confusion, the
They should
CBDT
come-
can quickly get in touch with some of those high commission and embassies, identify some of the valuers, have a tie-up with them,
That's a
notify
very-
them
that's
these
a
are the
very
valuers.
good
Good
and
enough.
practical way.
Some
out.
approved value.
Approved valuers, so that embassies could certify that we
These are
got in
approved
touch with them. That could be a solution to avoid this kind of confusion. Yes, sir. So we'll go to the interest liability.
So far as interest issue is concerned, they are silent in those sections 59 to 72. When we come to form number 6, with regard to each asset which is to be declared, they have given date of acquisition as one of the important columns. Now, what is an asset on the date of acquisition? It is your income. Asset represents your income. Now, a view can be taken and could be taken even by the authorities like C&AG that when there is no specific exclusion of levy of interest in chapter 6, unlike penalty and prosecution, why the interest has not been charged when the information was right before you as to when that asset out of undisclosed income was acquired. So it will be in the fitness of things if
make a clarification,
CBDT
yes.
clarifies this issue
Right.
so that there is no confusion. on
Right.
this.
And too much of litigation in future, sir, perhaps. So let me go back to all of you with the last round of, valuable suggestions for the CBDT, for the government to come out with a clarification with the objective to make the scheme a big hit, a big success. But let me start with Mr. Sunil Agarwal only. Sir, please suggest.
One, let the CBDT clarify that income chargeable to tax under Income Tax Act till the period 31st March 2015, which has escaped assessment, irrespective of the residential status of the assessee presently, whether he is a resident or non-resident, so long as the foreign asset or income represents income chargeable to tax under Income Tax Act and having escaped assessment so far. Number 2, regarding valuation, there was very good point. And valuation, I think the best would be this Indian embassies and high commissions approving the list of valuers. And that valuation should be accepted. The one more point that I said earlier also, that somebody who wants to really come clean, he has got financial stringency or financial inadequacy by 31st December. The government can allow that payment of taxes maybe later than that date, maybe subject to interest.
Perfect. Yeah, Mr. Rohit Jain,
Yeah, I
please
just
tell
want to make two or three important points which in fact requires clarification from the CBDTs. One example, in fact, one specific practical query which came to me was that I purchased an asset say of rupees 100, but I took a loan of 80 rupees outside. Now, what amount I have to declare? If we strictly go by the scheme of the Act, I have to declare 100 rupees as my undisclosed asset because that's the fair market value of the asset. And it does not, in fact, there is no provision for reducing the loan amount which I have taken outside India. And therefore, for a person who has actually invested only 20 rupees, for him makes no sense to declare 100 rupees and pay 30 and 30 rupees, 60 rupees as tax.
No incentive to come forward.
So that I think that requires clarification. That the second point was that in case of a trust, actually there is still ambiguities which are left, because most of the people have created trusts outside India, which are more or less a discretionary trust, and there are 4 or 5 discretionary. There are 4 or 5 beneficiaries. As this act stands now is what to my mind it appears is that the person who has actually settled the trust is required to make a declaration, because he has created the trust out of his undisclosed income by settling the amount in trust. But he may not be wanting to do it because he may be a non-resident. The beneficiaries may be in India. So therefore, an Indian beneficiary may want to declare it, but the act probably prohibits it from declaring it. First point. Second point is, if it is a discretionary trust, how to calculate the benefit? Because my benefit is dependent on at what point of time the amount is actually declared. And this is what the Supreme Court has also said, that in case of discretionary trust, a beneficiary has nothing but then a hope that something will be declared at some point of time by the trustees and I will be receiving it. Right. So in case of trust also this clarification is required. Third point is that in case of certain assessments which have actually been concluded recently, what had happened was there was assessments. The assessing officer was unable to obtain the information and he concluded the assessment at nil income. Now the act says that once a particular issue is subject matter of an assessment, then I can't disclose it in a compliance scheme. Now that assessee whose information was not received during the course of assessment, and assessing officer left it open by saying that if I receive the information tomorrow, I will reopen the assessment. But the assessee may want to declare it. Now a clarification, if it has come out that now we have not been able to receive the information, if you want to make a compliance of it, you want to come forward and declare it, then maybe come forward and declare that amount. I think that also maybe requires clarification. And fourth point is, where an asset is disclosed. In fact, a query came to me from someone. He was a non-resident, he acquired certain assets, which resulted in subsequently incomes. Now incomes he want to disclose. He doesn't want to disclose the assets. How to calculate it?
Yes, sir. We will come to you, sir.
I would make 3 points.
Sure.
The first point is with regard to facilitating the process of valuation. That's cumbersome for a number of issues, even such a simple thing as taking the value of a bank account, as I mentioned earlier. Right. That all the information as to when the account was opened, it could have been 20 years ago, and all the accretions by way of deposits made to it have to be informed by the declarant. So there some help is required, because the window given for all this valuation is just of 3 months. Similarly for unlisted shares, and there are other problems also. So there the government should, the CBDT should come out with a very clear scheme of clarifications as to how this can be done. Some of the suggestions have come that there could be some approved valuers, courtesy of our high commissions and embassies. And regarding the bank's problem also, if beyond 10 years the bank are not able to provide the information, yes, then what should be done?
Right.
So that's the first part. The second part was, again, we have discussed this issue at length, that a clarification should be sought with regard to the levy of interest for the declarations made under Chapter 6. And third issue, because it's a very important scheme, and we are hoping that, not only hoping, we are more or less confident the scheme would be successful, because the chances of a person being found out are now fairly high. But still, a lot of publicity should be given to it, not only in India, but also through our missions abroad, so that not only the finer points of the scheme, but also the clarifications which have been issued by CBDT should come to the knowledge of the prospective declarants.
Absolutely fine, sir. Yeah, Poorva.
Yeah. One is, of course, the timelines. The window timeline is too short. The 3 months and the tax payment timelines, because that's going to be really a practical difficulties. Then what I do feel is that this FAQs, they came out too quickly, after the circulars and all. So they should really come out with some more, they should come out quickly with some more clarifications on issues like what could constitute an asset, give some illustrative examples so it avoids an ambiguity. the issue on residential status, something like where there's a genuine mistake on rectifications and all that, So people are not just kind of worried, that it all gets treated like a void declaration. And then, of course, if at any point of time when they make a declaration in a good faith and those assets are excluded out because of, they don't have an information right now, I mean, there's an information already available, then they should actually be given some kind of an assurance that there will be no kind of harassment value or other things which would be there. Because, see, at the end of it, we have to also ensure a very compliant process, while the provisions are very harsh for the people who will make a declaration. But I think those are the kind of things which will really augur well in making people come forward and making a declaration.
Wonderful.
Yeah.
So on this note, we would like to wrap up this debate. We have been, all the four panelists have been making very realistic, down-to-earth suggestion to the policymakers, to the Honorable Finance Minister, how to make this scheme a little more relevant, little more attractive. And what could be the USP of this scheme is perhaps one clarification is like, for instance, interest, which the department is very fond of using this instrument quite often. And if you go to the legislation, if you go to the scheme, there is certain grey areas where a clarification is required. Then we come to the valuation part. Valuation is perhaps the quagmire, where a lot of litigation, if you look at the trigger point of valuation, it generates a lot of litigation. Since the objective is to earn some revenue, let the declarants come forward and contribute to the exchequer's richness. The idea is that valuation dispute should be avoided. For that, very valid suggestions have come from the panelists that maybe the Indian High Commission or maybe the embassies could be involved to notify a list of values, and whatever the values being given by them, that should be accepted by the department without any dispute, without any question. That is another aspect. Another very interesting aspect which has come is perhaps this timeline. Timeline is another very important dimension where it is too short for the potential declarants, because when the prospective declarants are entertaining too many doubts, too many questions, they are interacting with a lot of consultants, a lot of law firms, and maybe even the revenue authorities perhaps. 3 months window is not adequate. So maybe the government could think in terms of coming out first with quick clarifications, extending the window, and also giving perhaps additional window, because the financial hardship, given the recession which continues from 2008, it is still accelerating. Liquidity could be a major issue. Perhaps for paying taxes, some additional window could be provided in certain cases. Of course, the government could use discretion, going by the facts, looking at the financial hardship aspect. Then we come to this dimensions of, maybe the information part. Some of the, our panelists have given the gray areas where additional input will be appreciated more. Maybe the FAQs could be revised. A few FAQs, some of the questions could be deleted perhaps, which are actually generating conflicting interpretations in the mind of experts. Ultimately, experts are the windows to, for the government of India to reach out to the potential declarants. So maybe the experts must not be given too much of wide window, so that they interpret and misinterpret, and that will confuse the, the prospective declarants. So perhaps the TPL, the CBDT needs to look at some of the FAQs, some of the conflicting, the interpretations. Probably the circular is not consistent with that. Some of the FAQs are perhaps not consistent with the provisions of the law. Looking at all these dimensions, CBDT should come forward with more detailed clarification, incorporating some of the suggestions from panelists, from more. I'm sure the CBDT must be receiving a lot of representation, a lot of input from other windows. We happen to be just one window for this compliance window. Let me thank all my panelists for wonderful suggestion, for wonderful insight. Objective is to make the scheme more tempting, more titillating for the prospective declarants. Come forward and contribute to the exchequer. Thanking you all for watching TIOL Tube.